I moved to Maplewood Estates 3 years ago, drawn by the tree-lined streets and charming craftsman-style homes that dotted the neighborhood. The community seemed perfect: quiet streets, well-maintained properties, and a genuine sense of belonging. What I didn't realize was that our homeowners association president, Karen Mitchfield, treated the position like she'd been elected supreme ruler of a small nation. She patrolled the streets in her white SUV with the intensity of a general inspecting troops, a laminated copy of the HOA bylaws perpetually clutched in her manicured hands. I first encountered her true nature 2 months after moving in, when she left a violation notice on my door because my trash cans were visible from the street for approximately 45 minutes past the 7 a.m. collection deadline. The fine was $50. I laughed it off, paid it, and assumed that would be the end of it. I had no idea that Karen had just marked me as someone who would comply, which in her mind meant someone she could target again and again. The incidents escalated slowly at first. A notice about my lawn being a quarter-inch too tall. A complaint that my car was parked 3 inches over my driveway edge. A citation because my front door wreath extended 2 inches beyond what she claimed was the approved decoration boundary. Each violation came with a fine ranging from $50 to $200, and each time I tried to discuss it reasonably with Karen, she would smile that tight, satisfied smile and remind me that rules were rules. By the end of my first year, I'd paid over $3,000 in what I considered completely frivolous fines. I'm a corporate attorney specializing in real estate development and property law, so I started actually reading the HOA documents, all 647 pages of them. What I discovered was that Karen had been making up at least half of the rules she claimed to enforce. But proving it meant a lengthy legal battle with the HOA, and frankly, I had bigger cases to worry about. If you're enjoying this story of how one HOA president's power trip led to her ultimate downfall, please hit that like button and subscribe to Karen Eat World. Trust me, you won't want to miss how this ends. Your support helps me bring you more stories of karmic justice, and the algorithm loves it when you engage. Now, let's get back to how Karen's obsession with control became her biggest mistake. The harassment continued into my second year in the neighborhood. Karen began scheduling mandatory HOA meetings at random times, once calling one for 7 p.m. on Thanksgiving evening. Miss 3 meetings, according to the actual bylaws, and you'd face a $500 fine. She knew most people couldn't attend every single one, especially with less than 48 hours notice. I made it to all of them, taking notes, documenting everything. My neighbors weren't so fortunate. I watched as she drained thousands from families who were just trying to live their lives. The Robinsons down the street nearly lost their home because they couldn't keep up with her arbitrary fines while managing their daughter's medical bills. That's when I stopped seeing this as a mere annoyance and started seeing it as what it really was: systematic financial abuse hiding behind a veneer of neighborhood standards. Everything changed last Christmas Eve. I'd just returned from visiting my parents upstate, pulling into my driveway around 9 p.m. with my car full of presents for the neighborhood toy drive I'd organized. I'd been coordinating it for months, collecting donations, arranging distribution to local children's charities. As I was unloading boxes from my trunk, Karen's SUV screeched to a stop in front of my house. She emerged wearing a red pantsuit that somehow made her look even more menacing, her phone already raised and recording. Well. Having a little late-night party, are we? Do you have a permit for this gathering? I count at least 15 violations here. Unregistered guests, after-hours noise, and are those commercial vehicle markings on some of those boxes? You know commercial activity is strictly prohibited in Maplewood Estates. I stared at her, a box of toys for underprivileged kids literally in my arms. Karen, these are donations for charity. There's no gathering. I'm just unloading my car. She stepped closer, her phone's camera light glaring in my face. I see alcohol containers in your vehicle. Have you been drinking? You're clearly intoxicated, which explains why you're causing a disturbance on Christmas Eve. I'm calling 911. I set the box down carefully, keeping my voice level. Karen, those are empty wine bottles people donated for a recycling fundraiser. I haven't been drinking. Please don't waste emergency services time. But she was already dialing, and I heard her dramatically tell the dispatcher that there was an intoxicated person causing a disturbance, refusing to comply with community standards, and potentially threatening her. She actually said the word threatening while standing on my property, recording me holding a box of teddy bears. 2 police officers arrived within 10 minutes, and I'll give them credit, they immediately seemed skeptical of Karen's breathless accusations. I calmly explained the situation, showed them my driver's license, submitted to a completely unnecessary field sobriety test that I passed with flying colors, and showed them the charity documentation for the toy drive. The younger officer actually looked embarrassed as he apologized for the inconvenience. Karen, however, was furious that I wasn't being hauled away in handcuffs. As the police left, she shouted across my lawn that she'd be filing formal complaints with the HOA board, which was ironic since she essentially was the board, having structured it so that she appointed all the members herself. I spent Christmas Day doing what I do best, research. I looked into every property transaction in Maplewood Estates for the past 15 years. I examined the original developers' agreements, the HOA formation documents, and every amendment Karen had pushed through during her 7-year reign as president. What I found was fascinating. The neighborhood had been developed by Grandview Properties, a mid-sized real estate company that had dissolved 12 years ago. However, the original development agreement contained a provision that I'd seen before in my professional work, a reverter clause. Essentially, if certain conditions weren't met, development rights would revert to the original property owner or their assigns. And those conditions? They included maintaining common areas, which Karen had been neglecting, while obsessively focusing on individual homeowners' minor infractions. The community park was overgrown, the neighborhood entrance sign was falling apart, and the retention pond was becoming a mosquito-infested swamp. All violations of the Master Development Agreement that superseded the HOA bylaws. Even more interesting was discovering who currently held the rights to that reverter clause. After Grandview Properties dissolved, those rights had been sold off piecemeal to satisfy creditors. Through 3 different shell companies and 2 private equity transactions, they'd ended up with a small investment firm in Delaware. It took me 4 days and several calls to former colleagues, but I managed to get a meeting with the firm's principal. I won't bore you with all the legal details, but I made them an offer for those rights that was generous enough to get their attention but small enough that it barely made a dent in my savings. My salary, as a senior partner at a top corporate law firm, plus some very successful investments over the years, meant I could afford to play the long game. By January 15th, I owned the development rights and the reverter clause for Maplewood Estates. Now I just needed to document Karen's violations thoroughly before making my move. For the next 3 months, I meticulously photographed every instance of common area neglect. I attended every HOA meeting with a court reporter I'd hired, creating official transcripts of Karen's statements. I filed public records requests for the HOA's financial documents, discovering that she'd been spending community funds on personal expenses, always small enough to avoid serious scrutiny, but definitely outside the bounds of her authority. $2,000 for a new laptop that she claimed was for HOA business, but was actually used primarily by her teenage son for gaming. $1,500 for office furniture that ended up in her home office. Multiple dinners at expensive restaurants categorized as board meetings, but attended only by her and her husband. None of it was technically illegal, just deeply unethical, and definitely against the HOA's own financial policies. I compiled everything into a file that would make a prosecutor weep with joy. Not that I was planning to involve prosecutors. What I was planning was far more elegant. The Master Development Agreement specified that if the developer, or their successor in interest, which was now me, determined that the HOA had materially breached the maintenance covenants, they could reassume control of common areas and levy assessments to bring them into compliance. This was designed to protect property values if an HOA became dysfunctional. Karen had made the HOA incredibly dysfunctional, just in ways that most residents hadn't fully recognized because they were too busy dealing with her individual harassment. I had my corporate litigation team, who owed me several favors, draft a notice of breach and assumption of control. It was 47 pages of devastating legal analysis, backed by photographs, financial records, and expert testimony about property maintenance standards. I had it served on Karen, in her capacity as HOA president, on April 1st. The date was intentional. I wanted her to think it might be some kind of joke, right up until she had her attorney review it and realize it was absolutely legitimate. The notice informed the HOA that I was exercising my rights under the Master Development Agreement to assume control of all common areas due to material breach of maintenance covenants. But here's where it got interesting. Those common areas, as defined in the original development agreement, included not just the park and retention pond, but also all streets, sidewalks, and utility easements within the subdivision. The original developer had retained ownership of these, granting the HOA only maintenance responsibilities. Karen had never bothered to verify this because in most modern subdivisions, those areas get dedicated to the municipality. But Maplewood Estates was developed just before that became standard practice, and the developer had kept ownership, probably planning to leverage it somehow before the company dissolved. Now I own them. And I was about to use that ownership in ways Karen's tiny, rule-obsessed mind couldn't possibly have anticipated. My notice further informed the HOA that I would be implementing immediate improvements to bring common areas into compliance with the original development standards, which were actually quite specific and had been completely ignored for over a decade. The estimated cost was $2.4 million. Under the terms of the Master Development Agreement, these costs would be assessed against all properties in the subdivision on a per-lot basis. There were 320 homes in Maplewood Estates, which meant each homeowner would be assessed approximately $7,500, payable within 90 days. The notice was completely legal, thoroughly documented, and utterly devastating. Karen called an emergency HOA meeting for that same evening, her voice shaking with rage in the voicemail she left all residents. I arrived early, sitting in the front row with my attorney, both of us in impeccable business attire. The community center was packed with confused and angry homeowners who'd received copies of the notice. Karen stood at the front, her face flushed, trying to maintain her authoritative demeanor. This is clearly a frivolous attempt to harass this HOA. This person, and she gestured at me without using my name, has been a problem resident since day one, constantly challenging our authority, refusing to follow simple rules, and now attempting this extortion scheme. My attorney stood smoothly. Mrs. Mitchfield, I'd caution you about making defamatory statements. Everything in our notice is based on recorded fact and explicit contractual language. If you'd like, we can go through each cited violation of the maintenance covenant right now, with photographic evidence. The room erupted in chaos. Neighbors who'd barely spoken to me in 3 years were suddenly demanding to know what was happening. Karen tried to regain control, insisting that the notice was invalid, that I had no authority, that she'd have her lawyer destroy me in court. I waited for the noise to die down, then stood and addressed the room. I understand everyone is upset. I'm not doing this to hurt any of you. I'm doing this because Karen Litchfield has been systematically abusing her position for years, and the only way to stop it was to go around the HOA entirely. You've all paid thousands in bogus fines while she's neglected the actual responsibilities of this association. The retention pond is a health hazard. The park is unusable. The neighborhood entrance looks like something from a horror movie. Meanwhile, she's been spending HOA funds on personal expenses and making up rules to squeeze more money from all of you. I have documentation of everything. I had my attorney distribute packets to everyone in the room. Hundreds of pages of Karen's violations, her made-up rules, her questionable expenses, all organized and tabbed. What I'm proposing is simple. Karen resigns immediately and surrenders all HOA authority. We restructure the board with real oversight and term limits. We bring the common areas up to the standards we all deserve. And we do it properly, with competitive bids and transparent accounting. If that happens, I'll work with all of you on a reasonable payment plan for the assessment, and I'll personally cover any costs that exceed what's necessary for basic compliance. Karen was sputtering, trying to interrupt, but her husband, who'd been reading through the packet, put his hand on her arm. He'd found the section documenting her personal use of HOA funds, and his face had gone pale. One of my neighbors, a retired accountant named Herbert, who'd been fined repeatedly for having the wrong shade of beige on his mailbox, stood up. I move that we accept this proposal and demand Karen's immediate resignation. The motion was seconded immediately. Karen tried to claim that this wasn't a proper vote, that there were procedures, that they couldn't just remove her. My attorney helpfully pointed out that according to the HOA's own bylaws, which Karen had amended several times to concentrate her power, the membership could remove any board member by a simple majority vote at any meeting where the issue was properly noticed. This had been noticed. It was in the emergency meeting announcement. The vote was 247 in favor, 3 opposed. I'm pretty sure the 3 opposing votes were Karen, her husband, and her mother, who lived 2 streets over. Karen stood there, her carefully constructed kingdom of petty tyranny crumbling around her, unable to process what had just happened. But I wasn't done. Not even close. The HOA reformation was just the opening move. See, in my research, I discovered something else interesting about Maplewood Estates. The subdivision had been built on what was originally a much larger parcel of land. The developer had only built on about 60% of it, leaving the remainder as a buffer zone that was supposed to eventually become a second phase of development. That land, about 40 acres, had also ended up in the tangle of transactions following Grandview Properties' dissolution, and it was currently owned by a different entity than the one that had held the development rights. It took me another month and significantly more money, but I acquired that parcel too. It sat directly between Maplewood Estates and the main county road, meaning every resident had to drive through it to reach their homes. The original easement agreement granted access, but it was surprisingly limited in scope. Specifically, it granted access for residential traffic only during certain hours and was subject to the landowner's right to implement reasonable regulations. Karen, meanwhile, was spiraling. She'd been forced to resign from the HOA, but was still living in the neighborhood, now subject to the same rules as everyone else. The new board, which I deliberately stayed off of to avoid any appearance of self-dealing, was actually enforcing real standards fairly and consistently. They'd hired a reputable management company and were bringing the common areas up to proper condition. Karen kept trying to attend board meetings and insert her opinions, but she had no authority anymore and was politely but firmly told to sit down and be quiet like any other resident. I watched her deteriorate over those weeks, her sense of identity completely wrapped up in the power she'd lost. She started filing complaints with the county, the state, anyone who would listen, claiming that I had stolen her position through legal trickery and conspiracy. Every complaint was investigated and dismissed. Everything I'd done was completely above board, which only made her more frantic. In early June, I filed for a zoning variance on my 40-acre parcel. I wanted to develop it into a mixed-use property with some light commercial space, a small public park, and a gated residential community. The County Planning Commission was enthusiastic because it would increase the tax base and provide services the area needed. The variance was approved with only one public comment in opposition, from Karen, who rambled incoherently about property rights and neighborhood character. The next week, I applied for permits to construct a new private road through my property, along with a staff security gate. This road would become the primary access point for my new development. At the same time, I notified all Maplewood Estates residents that effective in 90 days, as was required by the easement agreement, I would be implementing new regulations for the existing access road through my property. These regulations were necessary, I explained, to manage increased traffic from my new development and to ensure the safety and security of everyone using the road. The new regulations were remarkably simple. The access road would now be closed from 11 p.m. to 5 a.m. for maintenance and security purposes. Any resident needing access during those hours would need to apply for a special permit at least 72 hours in advance, with appropriate justification. During open hours, traffic would be monitored by security personnel I'd be hiring. Any violations of posted speed limits, which I was entitled to set on my private road, would result in temporary suspension of access privileges. Residents could avoid all of this, I noted helpfully, by using the alternate route to their homes, which involved driving an additional 12 miles around the county on back roads that added about 35 minutes to the commute. The Maplewood Estates HOA board immediately contacted me, concerned about the impact on residents. I met with them, and was completely reasonable. For the vast majority of residents, this would be a minor inconvenience at worst. Most people didn't come and go in the middle of the night. The speed limits I was setting were actually the legal standard, just now actually enforced. And I was providing plenty of notice for people to adjust their routines. There was, however, one more provision in my regulations that I'd saved for last. Based on my research into traffic patterns, safety concerns, and liability issues, I was implementing a temporary restriction on certain vehicles using the access road during its construction and improvement phase. This phase would last approximately 18 months. During this time, white SUVs of certain makes and models, specifically the kind that Karen drove, would need to use the alternate route, as their sideline profiles had been identified by my traffic consultant as posing elevated risks during the construction period when road shoulders would be reduced. This was based on actual traffic engineering data, and my attorney assured me it would withstand any legal challenge. It was absurdly specific, targeted, and petty, which is to say, it was exactly the kind of thing Karen had been doing to residents for years, just scaled up and with better lawyers. The night before my new regulations took effect, I was sitting on my front porch when Karen's SUV came screaming down the street and jerked to a stop in front of my house. She burst out, her face purple with rage, waving a copy of my access road regulations. "You can't do this. You can't ban me from using the road. This is harassment. This is discrimination. I'll sue you for everything you have." I took a sip of my iced tea and smiled calmly. "Karen, I'm not banning you from anything. You're welcome to use the road anytime you'd like, just not in that particular vehicle. It's a safety issue during construction. I'm sure you understand the importance of following rules for the good of the community. After all, you spent 7 years teaching us that lesson." She sputtered, trying to find words, her hands shaking. "This is because I tried to maintain standards. Because I tried to keep this neighborhood respectable. You're doing this to punish me for doing my job." I set down my glass and looked at her with the same cold smile she'd given me dozens of times. No, Karen. You didn't maintain standards. You weaponized them. You used your position to bully and extort your neighbors. You made up rules to satisfy your need for control. And now you're learning what it feels like to be on the receiving end. She threatened lawsuits, criminal complaints, going to the media, everything she could think of. I let her wind down, then explained the reality. She could challenge my access regulations in court, where she'd lose because they were legitimate and properly implemented under my property rights. She could try the alternate route, which would add over an hour to her daily commute. She could move out of Maplewood Estates, though given the property values and her financial situation after losing her HOA stipend and having to refund some of her ill-gotten fines, that would be difficult. Or she could sell her SUV and get a different vehicle, which would solve the immediate problem but require her to admit that I'd outmaneuvered her so thoroughly that she had to change her own transportation to accommodate rules someone else had created. Every option was legal, reasonable, and completely devastating to someone whose entire identity was built on being the one who made the rules. Over the next few weeks, I watched Karen's routine fall apart. She tried the alternate route for a few days, but the added time and the terrible condition of those back roads quickly wore her down. She showed up at county commissioner meetings demanding they force me to change my regulations, but they had no authority over private roads on private property. She tried to organize the other Maplewood residents against me, but they'd all read the documentation of what she'd done to them over the years, and their sympathy was in notably short supply. Her husband quietly reached out to my attorney to ask if there was any accommodation I might consider. My response was simple. Karen could submit a written apology to every resident she'd find during her tenure, along with a detailed accounting of every bogus rule she'd enforced, and I would consider modifying the vehicle restrictions. The apology needed to be specific, sincere, and acknowledge the harm she caused. Her husband took the proposal back to her. She refused. Instead, Karen went to the local news with her story, positioning herself as a victim of a vindictive neighbor with too much money and not enough respect for community values. She actually sat for an interview, tears in her eyes, talking about how she devoted years to serving her neighborhood only to be targeted by someone who couldn't handle being told to follow simple rules. The reporters seemed sympathetic until they started doing basic background research. Within 2 days, the news station had interviewed a dozen Maplewood residents who told very different stories. They had copies of Karen's made-up violations, records of her excessive fines, documentation of her financial mismanagement. The segment that eventually aired was titled, "When HOA Power Goes Too Far," and Karen came off looking exactly as terrible as she'd actually been. The final minute of the segment featured the reporter explaining how I'd used property law and development rights to essentially take back control from an out-of-control HOA president, and legal experts calling it a creative, if expensive solution to a problem that usually has no good answers. The story went mildly viral online, at least in property law and HOA horror story circles. Karen became a cautionary tale. Her name was literally being used in online forums as shorthand for HOA presidents who abused their authority. She stopped leaving her house except for necessary trips, and when she did, she had to take the long route in her white SUV because her pride wouldn't let her admit defeat by buying a different vehicle. I actually saw her one morning at the county planning office where I was filing updated development plans for my new community. She was there trying one last time to find some legal avenue to challenge my road regulations. We made eye contact across the lobby, and I watched as the full scope of what I'd done finally, truly registered on her face. She'd spent years wielding the minor power of an HOA presidency like a weapon, never imagining that someone might have the resources, knowledge, and patience to completely dismantle her little kingdom and turn her own tactics back on her 1,000-fold. In her eyes, I saw the exact same helpless frustration I'd felt every time she'd handed me another bogus violation notice. The difference was, my revenge was permanent, legal, and precisely calibrated to make her live with the consequences of her own behavior every single day. She opened her mouth, closed it, and walked out of the building, her shoulders slumped in final, absolute defeat. If you enjoyed watching Karen's empire of petty tyranny crumble into dust through the power of property law and strategic patience, please give this video a like and subscribe to Karen Eat World for more stories of karmic justice served cold and completely legal. Your support means everything, and trust me, we have so many more tales of entitled people getting exactly what they deserve. Hit that notification bell so you never miss an update, and let me know in the comments what you think Karen's next move should be, not that she has many options left. Thanks for listening, and remember, sometimes the best revenge is just knowing the rules better than the person who thinks they're in charge.